and welcome to today's edition of the News in Brief. In the headlines, Supreme Court says EC boards cannot be compelled to testify in election petition. Court orders all parties to file their written addresses by Wednesday. Counsel for John Mahama applies to reopen case. And Minister Designate for Defense says he did not order military to invade Parliamentary chamber. News in Brief is brought to you by
Graphic Communication is giving you the opportunity to have news not only in hard copy but also in a digital form. Download your Graphic News Plus now and choose your preferred package daily, weekly, monthly, and annually, and access free news on various interest areas as well. Graphic News Plus, connecting people through news.
And now the news in brief. After days of seeking to cross-examine the chairperson of the Election Commission, Mrs. Jane Mensah, in an ongoing 2020 presidential election petition, the Supreme Court today ruled that she cannot be compelled to testify. The petitioner had objected the decision by the first respondent to close its case by not mounting the witness box to testify and be cross-examined. In its ruling this morning, the Supreme Court said the EC and President Akufo-Addo had the right not to adduce evidence even though they had filed witnesses' statements.
The Society of Law's case like this petition also deals with witnesses who had served witness statements and have decided not to give evidence to be cross-examined. We are amended to state that our jurisdiction invoked in this election petition is a limited jurisdiction clearly circumscribed by law. We do not intend to extend our mandate beyond what the law requires of us in such petitions brought under Article 64, Clause 1. Challenging the validity of the election of a president. Simply put, we are not convinced and will not yield to the invitation being extended to us by counsel for the petitioner to order the respondent to enter the witness box to be cross-examined. Accordingly, we hereby overrule the objection raised by counsel for the petitioner against the decision of the respondents declining to adduce evidence in this petition.
Mr. Chikata indicated to the court that the petitioner intends to reopen his case.
We will now seek your Lordship's permission to reopen our case in order to have a subpoena on the chairperson of the Electoral Commission. Now, my lords, we know that we can issue a subpoena without leave, but since we have closed our case on the assumption that she would be, so we intend to file a formal motion.
After the ruling, the Supreme Court directed the lawyers to file their written addresses on or before February 17, 2021. Hearing has been adjourned to February 18 to allow the lawyers to orally address the court.
By the ruling just read, the respective cases of the first and second respondents are deemed closed. This court hereby orders that the parties hearing should simultaneously file their respective closing addresses or submissions on or before Wednesday, the 17th of February 2021. The petition is hereby adjourned to the 18th of February 2021 for counsel in this petition to highlight on the written address or submission so far for the petition to be adjourned for judgment.
As usual, after the court sitting, spokespersons for the petitioner and the second respondent had this to say.
The EC is accountable to us. She has to account for how did those errors arise. When did she discover those errors? What was the process of correcting the errors? We've seen for some regions there are different summary sheets, different collation sheets. How did that come about? Who's going to answer this? Apart from that, remember that the petitioner is not the returning officer.
The petitioner who petitioned the Supreme Court that nobody won the election and that he has 5 witnesses to prove that nobody won the election. He's called 3 of the 5 witnesses and in the end has closed his case. The first respondent said, I don't have any witnesses who I think have to respond to this supposed case. And so I don't intend to adduce evidence. So I close my case. Second respondent has said same and has closed its case. And now the court has given orders for when we should bring our written submissions. Our lawyers have started working on that. We hope to meet the deadline that the court has put out.
The Minister Designate for Defense, Mr. Dominic Nitu, says he did not order the military to invade Parliament chamber on January 7 during the election of the Speaker of Parliament. Appearing before the Appointments Committee of Parliament today, Mr. Nituwo said he did not have the capacity at the time to make that order.
Mr. Chairman, that is not a true story. I've already answered this question, that I didn't even have the capacity at that time. I was the Minister for Defense. So I didn't have the capacity at that time to move the military. And he knows, my friend, he's my very good friend. He knows that I had not spoken to him for a very long time. In fact, this is where I was sitting over there. I didn't go to any place.
Also vetted today was the Minister Designate for Foreign Affairs, Shirley Ayoko Buchi.
This is the House of Law. This is where laws are enacted. And therefore, I believe that the question must be asked whether Parliament is ready to repeal any such law. Fortunately, I cannot include myself because I'm no longer a parliamentarian. So Parliament must let us know whether this is what they want to do.
Thank you for watching. We'll see you again tomorrow with another edition. Stay safe and protect yourself from COVID-19. For more news, visit graphic.com.gh or log on to Facebook at Daily Graphic and on YouTube at Graphic GH. I am Juliet Echansafo.